welcome everyone to the Trailer Park Show. I want to assure you that Pokey is in the studio and Chris is running it in the booth as always, and we'll hear from Pokey later. Today we have a very, very distinguished panel of judges who are all running for the Third Court of Appeals, and we're going to, I think, walk fairly slowly through what the Third Court of Appeals is and how it fits into the whole scheme of things. But every one of these people is hardworking. 3 of them have been doing this already, and I want to hear a lot about how many pages you write every week, and whether you use Microsoft Word or whether you have something else special. So, yes, okay, that's a good idea. Justice Puryear, you're the first of all these judges to have reached the court, and we'll hear a little more about that. Scott Field has been on a while. Cindy Olson Bourland was appointed, I think, first, and then elected.
Right.
And Mike Toth was just put on the court in the last few weeks, and so is running for re-election or election from a position of incumbency. So you guys have been ranging over a 24, 25 county area, and you've had some of these appearances together, so you must have a sort of pattern that you use, and so who goes first? Who is it that explains how you fit into the larger judicial system?
I think they're pointing to me.
Okay.
Ladies first. So the third Court of Appeals covers a district that is very large in size. It's 24 Texas-sized counties, and that district is basically the heart of Central Texas. If you were to look at it on a map relative to Texas, it would stretch west of San Angelo up to Bell County, Belton, south down to Comal County, and east to Milam County. So the district is larger than 6 U.S. states. If you were to drive it from one end to the other, it'd be 6 or 7 hours. So it's a very big district, and all of those counties, when you think about the court system, all of those counties, day in and day out, the trial judges are trying cases. So we're appellate judges. We're not at the trial. We read the record on appeal. But in those cases, divorce cases, murder cases, child termination cases, cases of very serious import, start in those counties, and if anyone believes there was an error of law and they want it reviewed on appeal, they come up to the Third Court of Appeals. There's 6 justices, 5 justices and 1 chief justice, so there's 6 of us, and we sit in panels of 3. So not one of us makes a decision alone. It's always at least a panel of 3. So we handle all of those appeals from all of those counties, and what makes us unique among all of the intermediate state courts of appeals in Texas is that because we sit in the state capital, Travis County, we also, through mandatory venue provisions that I won't go too deep into the weeds and make the viewers go to sleep, but those cases start generally in Travis County. Any new law that the legislature advances, that's signed into law by the governor, anything that tangles with a state agency, and anything that has to do with state businesses, any industry that's regulated, any professional that's licensed, those types of very important appeals come to us. So the 2 takeaways would be a very huge district, and because of mandatory venue in Travis County and the state capital, on many of these appeals, we have a statewide impact.
One thing that is amazing to me, and you just touched on it, is that if anyone believes there was an error in law, they can come to you guys. You can't say, we're busy right now, we're not going to take this case. Is that right?
Correct. We have non-discretionary jurisdiction. So every case, we take it, we give it serious consideration, sitting in panels of 3, and we have just about 1,000 appeals filed with us per year. So a
1,000
very
a year.
high volume court, just for easy numbers, just under 1,000.
So sometimes three of you will decide something based on the record, and no one needs to come and argue before you. And other times you will call people in, ask for filings, briefings, and that sort of thing?
It just depends on the case. Most of the time, we can decide cases based on the record, and based on the briefs. Those things that people file called briefs that are really about that thick, they're not brief at all. But we review those, and can decide most cases. It's really only the ones we have serious questions about that we'll call in for a hearing. And part of that's just due to volume as well. We're trying to get out 1,000 cases a year, so we can't hold argument in every case. But the truth is, we just don't need it in most cases. We only accept the ones we truly need it in.
So someone's writing 200 decisions a week after week after week after week.
We recently had 5 of the 6 of us in the top 10 in the state in number of opinions produced. We're a very efficient court.
What's the average amount of time that it takes for a case from first filing notice of appeal to you all disposing of it with an opinion, when you've had hearings?
Well, I don't know the answer when we've had hearings. Generally, it's 7 months, just under 7 months from filing to disposition, which is down significantly over 10 years ago.
Absolutely.
But
It was up to almost 2 years, wasn't it?
well, no, not the average disposition time. It was, I think, about 11 months. But we did have a time where this court had more 2-year-old cases than any other in the state. Now we have 0. We're number 1 in the state in that regard.
And much of that depends on the parties themselves in the appeal. I happened today to notice a case on the docket that is a 17 case, and of course here we are almost 10 months into 2018, and when I began to look at it, the briefing is still not completed. Some extensions of time were sought in order to get briefs in by the appellant, the party bringing the appeal. Well, then there were extensions sought by the party responding to the appeal. There happened to be other parties in the mix, and the briefing literally is not yet completed, so we obviously wouldn't even be to the point of considering that case either on the briefs or setting it for oral argument. So there are circumstances other than just operation of the court that might cause a time difference in when one appeal is resolved as compared to another.
If I could just add to something that my colleague Justice Bourland mentioned earlier, the third court does not have discretion in the cases that come to it on appeal. That is in contrast with the Texas Supreme Court. And one of the major differences between the appeals court in Texas and our Supreme Court system, we have 2 Supreme Courts in Texas, is one of only 2 states that has that, is the fact that at the Supreme Court level, there's discretion in whether or not to grant further review of a case which has already been argued in front of a trial court judge and then argued again in front of an appellate panel. And so a very small percentage of cases will go from one of Texas's appeals courts onto the Supreme Court of Texas or Court of Criminal Appeals. What that means, as a practical matter, is the Third Court of Appeals, if you're in one of these 24 counties and you have a case which goes from the trial court onto appeals, it is the last court, it's the last resort for that particular matter. So it's particularly important that the judges on the Third Court of Appeal get the law right and are able to reach the appropriate outcome under the law that is in place.
Now, I know that the Supreme Court and Court of Appeals consider very few cases. Do you know how many times lawyers appeal and they're not granted certiorari or whatever, they're not heard? I don't know. Does the Supreme Court reject half of the cases that they're asked to look at, or?
It's more than that.
More than that.
I think it's about 90%.
It's about
Yeah.
90%. I
Okay.
don't know the overall volume of cases that are actually where the review is sought, but I do know it's 90% or less that they actually take and review.
And the Supreme Court in Texas is only looking at civil cases.
Right.
So it's not like our.
Court of Criminal Appeals.
Right, it's not like the US system. They're not looking at both. The Court of Criminal Appeals handles all the criminal stuff. So, you know, they're turning down 90% of the civil cases that are filed with them. And I have no clue what the Court of Criminal Appeals right
I feel like it's similar, but I don't know. I haven't seen articles written on that topic, so I'm
Yeah.
not quite sure.
So in the vast majority of cases, as you say, Justice, I've been calling you Mike for a long time, so I'm gonna have to get used to this. But you, as you were saying, you're the last court for most people. In most cases, there's not gonna be an appeal after you. In some cases, there is, and so at some point, when those two highest courts hear the case, I understand that 40% or so of the time you're overturned, and I thought at first, wow, 40%'s a little high, isn't it? But this means that the Supreme Court has decided, and the Court of Criminal Appeals have decided that your decision was right, and they don't need to take up the case at all in 98% of the cases, and then in the few that they look at, that's where you are sometimes, but not
Put
not
that
often.
into concrete numbers. I know we're all familiar with the numbers expressed recently in a Texas lawyer article, which in fact recognized the third court as the court in the state least likely to be reversed by the state Supreme Court. The numbers they cited were approximately 4,500 opinions issued by the third court over the last 5 years, and over that 5-year time period, the Texas Supreme Court accepted for review 40 of our decisions, so 40 out of 4,500,
right.
and then affirmed, I think, half of those 40 that they considered.
And that's not because the cases are really, really easy, right? You guys work hard.
Now, we easily have the most complex docket in the state because of the administrative appeals. And that's not, I say, it's not putting down other courts of appeals at all. It's purely what Justice Bourland said about our venue rules and what has to come to Travis County. You know, anytime a state agency is sued, you can imagine the complexity and the statewide impact that it has. For example, we heard a case very recently about whether the city of El Paso can have a sports arena downtown. And people scratch their heads and go, well, why in the world are you hearing something from El Paso? It's purely a venue issue. We decided whether taxpayers in the Texarkana area, or Northeast Texas, can be taxed for the overage on a utility plant up there. Again, we're in Austin and we're deciding that issue, and that's purely a venue issue because they sued the Public Utility Commission. And so that's the kind of cases, the complexity is huge.
Well, and people don't understand also that administrative codes each have their own rules and law that you have to comply with. So when you have an administrative case that comes up, you're not just looking at the usual civil rules and the rules of procedure and evidence that everybody else has to comply with. You're looking at their specific rules. The administrative code is like an encyclopedia. Which is why I used to litigate with an administrative attorney, and I said, well, I'm happy to go and argue anything you want, but you have to come and explain to me what the heck I'm supposed to be arguing about, because I'm not reading those books.
We're also unique among the 14 courts of appeals at this level. There's 14 courts of intermediate appeals, and they all, who grades our papers, are the two high courts, split civil and criminal. And there's a diagram we may be able to flash up on the screen that we created to demonstrate that. But to put that in why we're unique among those courts of appeals is this administrative docket. It falls within the umbrella of civil law, but it's administrative because often they've had a proceeding through the State Office of Administrative Hearings was sort of their trial level. Then they, quote unquote, appeal to the district court level in Travis County, mandatory venue, then to us. So there's been a lot of procedure before we see the case. And these are the kind of cases, a lot of our filings are now electronic, some are not, but these are the kind of cases that might have 40 boxes of documents for one case, a Public Utility Commission case, for example. And we're unlike the other courts of appeals in that we handle those, and our docket is more civil than criminal. The other courts of appeals are generally probably 60-40.
No.
criminal,
They're
civil?
almost 50-50, every single
50-50.
Court of Appeals. In
Okay.
fact, there's only one other Court of Appeals last year that was majority civil.
Wow.
We're almost 70%,
Almost 70%
69%
civil.
last year.
Well, and something else that people don't understand is that at the Court of Appeals level, you guys don't get to hear witnesses or have examinations of evidence. You just get to look at the record of what was done at the trial court level. Isn't that correct?
It's
Correct.
funny, because at church, I get asked all the time, hey, I got a jury summons, am I gonna be in your
Yeah.
court? And I immediately say no, and they kinda look at me like, wait, how did you know that? I didn't tell you what court is that? Like, because we don't have them, we don't have witnesses, we don't have juries.
It's hard to understand the way that all fits together, but you're exactly right. And if anyone has ever had a trial or been in court, they've seen the court reporter there typing. And that person is critically important because that's the record we're reading. That's the record we're reading since we weren't there.
And in reading it, that's one of the reasons that it's the trial court that you support the trial court, because they at the trial court level you can hear the inflections. They get to see the how the person appeared and how they spoke, not just what they said. While you all just get to see what they said. It's got to be much more difficult in evaluating a case on appeal.
It is, and it's sort of built in or baked into our standard of review on many issues. If it's an abuse of discretion standard, we're granting discretion to the court, especially on a factual type finding. And I'm trying to simplify this, but it is because they are there live, seeing the judge or the jury seeing what happened, and we're reading it on a cold record on appeal.
Yeah, the court reporter doesn't write crying
Yeah.
in parentheses next to things, or
Not unless it's audible.
yeah. We actually had a closing argument where I swear they should have put in singing, because the attorney was doing the closing argument was singing to the jury. It was very odd.
Interesting.
You guys missed out on that one.
Was he or she good?
No comment.
And but voice, not argument.
Oh, the voice was good.
Okay.
The argument, didn't carry as much.
I have a question about the subject matter, because I think most of us who aren't attorneys can't picture that entire credenza full of the code that governs all of those different technical areas. But we know that we all have friends who are in the oil business and they know everything there is to know about drilling, and other friends who are in the medical business and they know everything there is to know about anesthesiology or something. And so just in terms of subject matter, do any of you have a story for something that you learned about the world because you had to, because there was an interesting case and you just had to sit down and learn something?
I would say daily we learn. And
Yes.
I've been on the court 3 years, and I have learned, we learn daily because we have to research these issues. And I often think about my days in private practice where my clients would say, researching, why did we have to research this? Don't you know the law? I would say, well, when the legislature stops passing new law, maybe one day I can memorize them all. But these are very complex legal issues, and in civil law, there's lots of nooks and crannies that can be advanced in the briefing, and we have to basically figure all of that out and make sure that the trial judges below got it right.
Yeah, I think.
So inordinate amount of reading, research, and writing.
I think, Gary, kind of the typical lifespan is sort of today's headlines oftentimes are tomorrow's court cases or tomorrow's litigation, and tomorrow's litigation are next year's appeals. So, you can kind of see oftentimes as issues are coming up in the public domain that there's follow-on litigation, and then that some of that follow-on litigation ends up in the appellate venues across the state of Texas. And that's where these 3-judge panels come in. And as was said a couple times already, for the most part, these are the courts of last resort. That's where the matter will end, except for those few cases that the Supreme Court will entertain a further appeal on.
And I think to specifically answer the question you asked, if I understood it correctly, there are many areas where much of our initial work is just simply understanding the subject matter of the appeal. It has nothing really to do with law itself. Cases involving DNA testing, many of these public utility cases where maybe it's technology that's been employed, and a utility company is attempting to recoup some capital investment money pursuant to state law. Well, you have to understand just the background, the context of the case before you ever get into the legal arguments. So there is often a good bit of time that's spent just reading the briefs simply to understand the subject matter of the appeal before you ever get to the legal arguments themselves.
Am I understanding that you cannot go to the parties and say, we need to be briefed on this issue? We don't understand this part. You don't get any further arguments at all?
Well, we can.
We can, yeah.
I mean, we depend on the lawyers filing good briefs. It doesn't always happen, but we hope for those. But that's often why we set oral argument. Like I said, it's only if we have questions, really, that we set oral argument. And there are times where it's a technical subject matter, where, you know, perhaps you go to one another and talk about it beforehand and realize that no one really has background in this area, and there's some issues that we're not quite sure what, there's some terminology perhaps that we're not quite sure what it means. And that's a great reason to have oral argument, so that they can come and explain it to us and make sure, and we can make sure we're going down the right path.
You know, hearing about the factual complexity of the cases that come before the third court and the various moving parts in the law as well, it's incredible to also state that the third court is one of the fastest moving courts, obviously without sacrificing any kind of accuracy because it's the least reverse court in the state of Texas. But the clearance rate as well, and by clearance rate, what we're talking about is the clearance of the appeal from the third court's docket, is incredibly fast. And that, I think we talked about that earlier, that time has been cut down markedly. And having recently joined the court, I can really see why that is. The judges in the court work very well together, very collegial environment, finding ways to work through these cases in order to come to a resolution sooner rather than later for the sake of the parties that are wanting to know what probably the final decision in their case is going to go, how it's going to go, which way or the other.
So the clearance rate's above 100% because you inherited a backlog that you've started clearing out. At first, that's hard to figure out what that means, but
Right.
you are above 100%, above perfect. So that's pretty impressive. What percentage of the time do you spend sitting at the front of a room with your robes on and you're just listening versus the amount of time that you're burning the midnight oil and typing and just writing briefs?
We set and hear oral argument typically every other Wednesday from 1st of September until the end of May. And typically there will be 3 cases set in the morning for the morning panel, 3 cases set in the afternoon for the afternoon panel, and they'll generally take up 3 hours between the 3 of them. But because those are typically the more complex cases, the cases that are infused with many questions surrounding the appeal, there's a great deal of study time that goes into those before you ever get out into the courtroom to deal with the lawyers, simply because you want to know the case as fully as you can before argument starts up to make the most effective use of not only your time but the lawyers who are appearing before you. You have to know the case as well as you can to know what the questions are
Right.
that pop up from it. So.
And anyone who hasn't gone and watched those arguments, it's a beautiful courtroom with great seating, and it's got great acoustics, and anywhere you sit, it's always interesting to watch. I've had the privilege of arguing up there 3 times now, so
And
it's
our arguments are open for public viewing for anybody that wants to come listen in.
I try and send law students.
It is, it's very nice, and the cases that we set for oral argument are often such that our courtroom is full. Very interesting cases that are often fairly high profile, but something I don't think a lot of the local lawyers know is that we will travel twice a year. In fact, Thursday of this week, will be sitting for court in San Angelo. So our clerk kindly packs up the robes, and we go out there the night before so that we can, and we sit in the Tom Green County courthouse, a district court. They have a big one there that they set up for us, so it's set up for an appellate type arrangement rather than a trial. And then in the spring, we'll go to Bell County. And the lawyers in those districts and the parties, of course, enjoy not having to trek to Austin.
Yeah, Belton's got a beautiful new courthouse too.
Yes, our courthouse here in Austin, as you know, is right by the Texas Supreme Court and right by the Capitol. We're part of that Capitol complex area, so.
Yes.
And many of these cases that are argued, even though they come from one of the 24 counties in the third court's jurisdiction, have statewide impact. And the reason why many of them have statewide impact is they deal with regulatory law. So if you're a regulated entity under that provision of the code, whether you're in El Paso or whether you're in the Dallas area or whether you're in the Houston area, the opinion is going to impact the way that your industry is going to operate going forward. So it's one of these interesting courts where, like the other appeals courts in Texas, it covers a confined jurisdictional space. At the same time, the decisions, because of the nature of the legal questions and the parties that are involved, have impact across the whole state of Texas.
Well, and it seems to me that the even years, you guys would be hit with the new appeals on new laws that have gone through, new changes in administrative law that have happened in the even year when the legislative session ended. And so you probably get a glut of certain types of cases in the even number years until there's some opinions that can help guide the courts, the trial courts, more in deciding those particular things.
And I'm not sure we even feel it until maybe a year after
Right.
that, because it'll go
Exactly.
to that trial court first, immediately. Because I've heard our federal judges talk about that, and our state district judges talk about that they're hit almost immediately. And then about a year later, it'll pop up for us.
Well, with the Me Too movement, I've been seeing a lot of anti-SLAPP, which in Texas, that's not what it's called. That's the federal lawsuit. But a lot of those cases go through. And actually, law firms that are specializing in it nationwide who are then getting local counsel to argue those here. And it's interesting trying to explain to them the difference that Texas just doesn't play exactly that way. So
Let's
but
talk
there'll
about
be lots of those.
judicial philosophy. I think from the point of view of the layman, it sort of looks like judges get to just decide what's right and what's fair and what's equitable, and you can just make up a ruling because it's the right thing to do. And it sounds very appealing. And I think I've heard judges running for office saying that they're going to try to make sure that there's diversity. That I'm in favor of diversity. That sounds like a great idea. That there's fairness and that you're giving the little guy an even chance or whatever. But let's talk about judicial philosophy and whether or not you really are in a position to just sort of think up what's right and just tell everybody that you have decided.
Well, I think, I recently took the oath to be a judge in the state of Texas, and I think that's a great place to start, because the oath that we all have sworn to is not an oath to make up the rule that you consider to be the appropriate rule in that particular case. The oath is to apply the law and the Constitution as it applies in that particular case. And, I think that gives us a real, obviously, guidepost as to what judging is really all about. This also kind of gets back to this basic question I think we have all the time, which is we have a system of 3 branches of government. We're all subject to the law. We're all subject to the Constitution. We're all subject to the legal system that we have in place in the state of Texas and in our country. And so judges, like the members of the other branches of government, have a legal standard, have a set of rules that they need to follow. And what it basically comes down to is applying the law that's in place for that particular case that comes before the court. And the court needs to determine if it has jurisdiction over the matter, and once it determines that it has jurisdiction over the matter, then it uses its authority to apply the controlling law to that particular set of facts. That is what our oath tells us to do. And so our role is a role that is prescribed and circumscribed by the controlling law and the Constitution and the system that we've set up in the state of Texas and in our country.
Great. I think you and I, Justice Puryear, had a conversation where you might have to make a decision according to the law that you almost wish could go the other way, and you wish that the legislature might make a change, but you just don't get to make up the rules or the laws.
No, I think every one of us has had to sign off on an opinion where we personally didn't like the result. But if you are following your oath to first find the applicable law and then apply that to the facts before you, the result is what it is. And going back to Mike's comment about the separation of powers, if we engage in that exercise, you apply law to fact and you don't like the result, that should serve as a signal to the legislature to perhaps go back and revisit the law and perhaps revise the law.
Which
But
they do.
it is not at the appellate court level or at any level. It's not a function of the judiciary simply to divine what seems to be a fair result in any particular case and then arrive at that result, because what you have then eliminated from law is consistency and predictability.
I want to follow up on that because I'm a big believer when we elect our judges in Texas. If you go to a sitting judge and they can't rattle off for you at least a couple of decisions they've had where, or examples, not maybe the case name, but the subject matter, where they've had a case they've had to decide where they didn't like the outcome. Because a good judge, it happens a lot, actually, that you don't like the outcome. And like David just said, the reason a good judge isn't going to worry about getting the right, fair outcome is we want our justice system as citizens and as business people and as, just people in the world. We want our justice system to be predictable. We're all governed by it. We're governed by the rule of law. And if we want to follow the rule of law, we need to be able to predict what behaviors will go awry of that, what behaviors will follow that. And if you have a judge on an appellate court especially, because what we do, every opinion we write is binding precedent for future cases. If you have a judge that's picking winners, you can't predict what's going on because they're just picking who they want to win and what makes them feel good inside, instead of actually respecting the rule of law and applying the facts, the law to the facts.
So that is the ultimate fairness, is that everybody plays by the same rules because the law is the same in every case, and you don't get to bend it one direction or bend
Well,
it
if you're
another
picking
direction.
winners, you're also letting bias creep in. You're letting your bias for whether it's a particular side of the docket, maybe in a criminal case for the prosecution or the defendant, or I don't know, perhaps there's a lawyer appearing in front of you that you really like. All those things can creep in if you're just picking winners. If you're just applying the law to the facts and ignoring all of that, then you're going to come out in a way that, again, is predictable and consistent over time.
And that,
I'm sorry.
well, I would just add to that. That is systemic. That's not just at the judicial level. Of course, it's critically important that we're not picking winners based on sympathy or who we like, winners and losers, but in terms of procedural fairness, so that people have a fair and just interaction with the Texas court system. It starts even like with Maura being in private practice. Someone walks into her office and says, this happened to me, do I have a lawsuit, can I sue? She has to vet that, or I've been sued. She has to look at the laws that exist and have some kind of ability to predict for her client the consistent outcome. Is there even a case? And that follows all the way through, all the way up to the Texas Supreme Court, and that's why we rely on things like precedent. Okay, we're bound by Supreme Court opinions. That's the court that grades our papers. And so that is throughout the justice system, the criminal justice system, the civil justice system in Texas. And it's critically important that judges not veer from that, because then it means somebody didn't get a fair shake, a fair procedure. They may not like the outcome. Every day when we sign opinions, 50% of the parties are unhappy, the party that didn't get the outcome they wanted. But sometimes the judge is unhappy too. As my colleagues just said, we don't often like the outcome, but we have to apply the law that is before us that applies to the case.
Yeah, I mean, just to sum this up, I think a judge who is happy with every single decision that he or she signs on to or hands down is probably not doing a good job as judge. And that's really one of the many reasons why we have this oath. It's to sort of remind those of us who have the opportunity to serve in this capacity that there's something larger than ourselves that we're a part of here, that we're acting in service of. So, you know, if you start to think about your personal views on a matter, or, you know, if you were king, how things would be for that particular day, you go back to, okay, well, what authority do I have here? You know, what have I promised the people of Texas? What standard have I promised to abide by and uphold? And that's why it's so important for judges to always live up to that oath. And always, in all cases, large cases, small cases, there's always going to be parties on both sides of it. You're always going to have a situation where there's going to be a side that prevails and a side that doesn't prevail. In every one, 100%, to apply the law to those particular set of facts. And in that way, we're fulfilling the function and the great amount of responsibility that was put into us by the people of Texas.
Great.
Well, and that's why it's a system of checks and balances. It's supposed to be that you're making things line up correctly, not system of flips and turns. You know, if it was flips and turns, you'd never know what the law was.
Some kind of mood they're in this year or something. What do you want to talk about? Why on earth you wanted this job? I hear the public looking at salaries that congressmen make or other officials, and it's my experience that every single one of them could quit what they're doing and double their income probably within the next year. So I'm not going to ask you how much money you make or how much you think you should make in the private sector, but I think you're making less. Why do you do this job? What is it that floats your boat and makes you come to work?
I'll let someone else answer the actual question, but one question to ask people when they're running for this office, if they are seeking a pay raise, worry greatly about that person. And then someone else can.
Well, you get paid more than active duty Marines.
That's true. That's all. That's true. But oftentimes we are the lowest paid lawyers in the courtroom.
Well, I'll answer that. I was appointed to fill an opening by the governor, and I applied for that in 2015. And I had been in only private practice, and of course it was a pay decrease, but this is a form of public service, and I had a good run in private practice, and I may go back to that eventually. Hopefully not next year if I don't prevail in November. But the impact that we have is so great that it's an honor to serve, and I'm glad that people of this caliber are willing to do it. And it's sort of like everyone has a gift that they can go contribute, and this is the one thing that we, and I probably speak for my colleagues, but at least I felt I'm good at solving legal problems and reading these briefs and figuring this out, and I can do that, and I want to do it. And I feel good about the contribution that we're making to the state of Texas because of our record and our efficiency.
And for those of us who believe in a system that is governed by the rule of law, you know, I want to wake up on any given day and know that the issues within my own community are being decided by the rule of law, are being decided by application of the controlling law to the facts of the case. And so what better way to ensure that than to offer yourself to the public service of serving as a judge if you're one that truly believes in that oath and will follow that oath very diligently and ensure that the cases that come before you are decided by controlling law and nothing else.
Well, I want to say thank you, not for the whole show. We're not to the end yet, but I want to say thank you for your service because you know, it's hard in America, it's hard in any capitalist system to say, okay, well, I'll make less than what I could make. And I appreciate that, and I know that other voters should appreciate that too. You've got two other members of the team, the Chief Justice, Jeff Rose, and Melissa Goodwin. So the six of you are really a team. There's nobody who goes off and does something all by themselves. This is a team we need to keep together.
Well, we decide cases in panels of 3. So, you know, just by structure, we have to be a team. We have to work together. And if you inject into that structure, you know, basically like, you know, sticking the rod into the bicycle spoke, you know, everything starts grinding to a halt. We work well together. By no means does it mean that we always agree. We routinely disagree. But when you have respect for the people you're working with, you tend to be willing to discuss why do you think this way, and then how do we reconcile what I think, and you can get to where you need to go. And I think we're lucky in that regard. Part of our efficiency numbers and everything else is because we have that kind of relationship at the court.
And there's a reason why our Constitution mandates, our laws mandate that we serve as a panel, and that is because a collaborative effort when you're talking about these issues of law is going to produce a more complete, comprehensive, well-considered opinion than if that authority were just simply vested in one. It's routinely the case that no matter how much time and effort you may have put into an initial draft, when you get with your colleagues and you're discussing it and you're revising and editing, there are thoughts that come into play that, you know, maybe never occurred to me in the first instance. And so it is that collaborative effort that yields, I think, the most complete product.
And I would add to that our system, you know, that if anyone's been in a court case, as I said, there's one judge up there in a black robe. Judges have a tremendous amount of power. You know, they can take away children, you know, parental rights, properties, liberty, life, death verdict, those kinds of things. The trial judge, and sometimes the trial judge might make an error of law just accidentally. They're under a tremendous pressure to turn in all those 24 counties. So again, we're not trying the cases, we're reading what happened, and it's essentially quality control, and we sit in panels of 3, so there's not just one of us. It requires 2 votes for a majority, and oftentimes there might be a dissent or there might be a separate writing of concurrence.
I have a question. Can I ask a question?
Yes, sir.
Can y'all tell me why said dump truck drivers should pay attention to this race?
You know, many reasons. Number one, I always tell this to people, for example, if we're out in San Angelo, you'll pay attention to our cases that are from Austin, and they're like, well, why is that? Because our opinions that come out from our court, even if it has to do with a dispute in Austin, applies equally to a person in San Angelo. And applies equally to a person in New Braunfels and Temple and Fayette County. If you're driving a dump truck, you know, perhaps there are a set of regulations that apply to dump truck drivers, and an opinion comes out from our court, and you're a dump truck driver in New Braunfels, and we issue an opinion about someone in Bell County, you need to pay attention to that. It's going to apply to you too. Negligence issues. You're on the road, you're driving, and you get a case where a dump truck's in a wreck. You know, the standards of reasonableness when you're on the road and you're driving, those apply equally to you.
Transportation code, licensing code,
And chances
environmental
are that
code.
dump truck driver has a commercial driver's license. If the agency responsible for issuing that license were to take it away for some reason, or perhaps no reason at all, I'm guessing that dump truck driver is going to want to know that there are judges in place who will apply the law that establishes for him his rights under those circumstances.
And
Oh, no, please.
more pervasive than that, setting aside that profession, our opinions have an impact on the daily lives of the Central Texans that comprise that live in these 24 counties. So, because we deal with anything that's regulated, our decisions impact water rights, what you pay for cable TV, if there's a fight with the Public Utility Commission on what can be charged by someone, by a provider coming into town to a municipally owned utility. These kind of issues that we're sort of doing the non-glamorous work behind the scenes that impact, how your veterinarian that you take your dog to is qualified, how they hold their license. All of those things that aren't glamorous, they're not things that people are screaming about on the national news, but they really impact Texas in a phenomenal way, much more than some of the federal issues. And again, it's not as interesting, but it has a big impact, and it goes beyond what profession you might have.
Representations that are made to you by your automobile dealer, did they make misrepresentations? If they sold a lemon, or are they complying with the state lemon law? Just every aspect of daily life is coming before us at some point.
What are the limits of what they can do with the information they collect from you during any transaction or licensing or registration? I mean, you guys get to look at those things too when people believe that their personal information has been sold or distributed.
Well, I think the issue too, I mean, whether you're a dump truck driver or a plumber or an accountant, it's, are you going to have a role in the future shape of our society? And so if you're interested in what's going on in the public domain and you're a truck driver or you're a plumber or you're an accountant, whatever your profession is, you can have a role in the process. You can vote in the legislative elections. You can get out and you can support a candidate, and you can help out with your free time, and you can go to the legislative arena and you can participate in the debate. You can provide testimony at the public hearing, and you can hold your leaders accountable, and you can have a role in the legal process, in the making of law across the country. So then if a judge comes along and usurps all that, what has become of your role to shape the future of our state as a truck driver, as an accountant, as an electrician, as a stay-at-home parent, as someone who's retired, whatever it is that you do, we all are invested in the process that we have under our Constitution. So in that sense, the decisions that judges make, whether they follow the law that's been democratically enacted, whether they abide by it as written, or whether they take that role onto themselves, affects everybody across our society, because it can literally change the social contract that we have, regardless of where we fit in. Everybody's equal under that contract. But if a judicial officer comes along and says, I'm going to rewrite it, then what becomes of the participation of the truck driver who took time out of a busy schedule to go over and help out a certain legislative approach, or went and testified, whatever it may be? So that's really where we are protecting. If we do our jobs right and we live up to the oath, we're protecting the process that we have in place across all of society.
Well, and anyone in the state who is licensed or deals with anyone who is licensed or authorized, or if you just look at the administrative code and all the codes there are, education code, there's a water code, there's a
lot.
code for everything, you find how much this particular court is going to impact your life.
And I guess if you're an ordinary citizen, you can go get a lawyer and say, this new law is wrong, it's not fair to me, and that's how those cases start, I guess, in the district courts, and they eventually make their way up to you. And if you're a dump truck driver, you can start a public access television show and change thousands and thousands of votes. And one other thing, Mr. James Ritter is known as Pokey because you were so careful on the road, is that right?
Never get in a hurry. I'll tell you that right now. Don't never, 18-wheeler or 4-wheeler, don't never get in a hurry.
I agree with that.
Great,
That's my public service announcement. Never get in a hurry.
great. We got some minutes left. How
Okay,
many
okay,
minutes?
See what happens when somebody gets in a hurry.
This is,
I think we have 3. So Mike Lee, who isn't here tonight, did send a couple of questions, and the thing that that both his questions have in common is it's asking about prosecutorial misconduct and corruption. And is that something that you all have seen much in the appeals that have come to you?
I can't say that we really have. In fact, I mean, I can't really think of an instance where that was the issue at hand. I guess the closest that might have been the issue before us is actually the Michael Morton prosecution, where it in fact was the Third Court of Appeals that ordered the testing of the bandana that ultimately led to the exoneration of Michael Morton. And of course, embedded within that were some issues pertaining to possible prosecutorial misconduct. But that really is the last case that comes to mind where that had any of those sorts of issues.
Well, and as for judicial misconduct, I'm sure that gets alleged all the time in the briefs that you see, but since only a small portion of those you actually opine upon.
I'm just gonna lean right here
I
for a
think
minute.
that it
Lean on in.
indicates you aren't finding as much judicial misconduct as people might allege.
Well, this is gonna take over 5 minutes, I know, cause you're gonna have to give me a translation on what the heck y'all are talking about on this one.
I think I can answer it quickly.
Can you? Thank you, ma'am.
It's those issues, prosecutorial misconduct or judicial misconduct, something went awry in the trial below. Those are sort of built in or baked into the legal issues that we see on, for example, a motion to suppress. Should that evidence have been let in? Did the prosecutors give it to the criminal defendant's lawyer in a timely fashion or give notice? Did the judge abuse their discretion in setting these custody guidelines or awarding this kind of support? Did the trial judge abuse their discretion in terminating the parental rights? So it's, by the time we see the case, it's sort of built into the issues, and that's what we're looking for in addition to other errors that the parties raised to us.
And that's what you're looking for is errors.
Errors.
Shyster lawyer, would that
That would be
qualify
an
as a
error.
kind of that's something I can recognize with.
It would, yeah, and it depends on what the parties present to us in their briefs. They don't often appeal every issue. They might limit it to to 1 or 2 issues, and that's what we review because that's all that they present to us.
Well, we appreciate y'all coming out. I had to ask that question because I can't articulate how important this race is. And you can come help any of these campaigns or all of them. And it is important. I can't tell you how much. And that wasn't too bad about it. I guess I used the truck driver thing, of course. If you got it, the truck brought it. So they have impact. And this isn't one of those exciting races like the city council or, of course, the state U.S. senator's race. And it's not the kind of judicial race that's going to have protesters out front either. But still, it is important that they're here. It is important that we do something like pay attention to these races. I'm sure we all agree, right?
You bet.
It has widespread impact.
We got about 3 minutes left. I'd like to know if there's anything, what else can we say here that would make people get excited?
Well, why don't we have everybody give their elevator speech?
There you go. I like that. Elevator speech quick. You got about 30 seconds to go.
Starting seniority.
The old man gets
I
it
would
first.
just say that I have had the pleasure and the privilege of serving on the Third Court for the last 18 years and certainly would like to serve another 6.
And this is your second time here on the Trailer Park Show,
It
is that
is. I
correct?
think I was here back in
I
2012.
think Mr.
Correct.
Field was here twice too, wasn't
I'm
he?
gonna say this is my second time as well. Scott Field, I've had the honor and privilege of serving you for 6 years and ask for your vote for re-election.
Damn, did I call you Mr. Field?
I-
Justice Field,
I'll-
Judge Field,
I'll answer to Scott or whatever you want to call him.
and I hope we see Cindy back here again.
Yes, Justice.
I mean, Justice Cindy.
it all works. Cindy is fine too. I'm
But
still
you never
getting
know
used
when
to it.
someone's level to wind up in front of you, so I gotta be polite here.
We all.
Outlaw truck driver stuff, you know.
My name is Cindy Olson Bourland. I'll be on the ballot in November. I have a website, justicecindybourland.com, that would tell you about my background and experience, and I certainly appreciate your vote and hope for it in November.
And I'm Justice Mike Toth. I've got a website too. It's www.miketothforjustice.com. Recently appointed by Governor Abbott, and I would be honored to have your vote so I can continue serving on the Third Court of Appeals starting on January 1st.
I thought we were just about to see a picture of you and the governor now, but it's all new equipment in there, and sometimes they can make it come up, sometimes they can't.
It's on the website.
Yeah, we'll have all that up somewhere.
Wonderful.
I mean, if you got the flower. Oh, there you go. Oh, there it is.
That's right.
I thought I was going to have to move out of the way for a minute there. That's my wife telling me to hurry up. Oh, yeah, with a minute left. It's always good. This your second time here, too, isn't it?
Third time. Not
Third
that
time?
I'm counting, but
I guess I get either too much oxygen or not enough when I start forgetting these things. It's always great to have Maura Phelen here. I know that. I don't know how many times she's been here.
Yes.
It's on the way home.
Well, it's really good to have you here.
Thank you.
And I hope to see you here again sometime, because it's good to have these kind of shows on, so these candidates can get some kind of airtime or just get out there. It's not an exciting race, but it is an important one, and I don't know how you guys manage to keep it all going sometimes.
A lot of ground to cover.
There is.
Well, and thank Gary for coming. He's working hard. So.
He's always here though. We're making him a permanent part.
A fixture.
Yeah, well, actually, we just depend on him most for pizza, but besides that, he's also pretty good because he can look nice when he puts his coats on. You see how I'm dressed, so this wasn't too much of a wait. Anyway, with 15 seconds, we'll be back next week, and we appreciate all y'all. And thank you, Anthony Wynn. He says hello from the Pflugerville Republicans out there, and he's taping the show, and we've been having trouble getting it on it. Bye, folks. Ran out of time like that. I want to get some
58
more.
and a half is it.
More photo ops before you leave.